Welcome back to the show. I'm Ben, your host, and this is Ben the Paralegal. And today, on a day in the life of a paralegal, the episode is about a child custody fight over school and a request to move away. What happens when a custody arrangement is working for years and then your child turns 5 and starts school? And because of that, one parent feels they need to not only move a county away for work, but also request full custody of the child when both parents have joint custody, even though they don't share equal time. Dad already had the child Monday through Friday. Mom had every other weekend plus one day on the week she didn't see the child to give the child continuity with mom. And they had gone through mediation originally when the child was 1. The child was now 5, starting school. They had gone through mediation, reached an agreement, and that agreement became a court order. So you would think the hard part was over for these two litigants, and it was. I mean, they've had some co-parenting issues as well, which you'll hear about, but it was not. Because now the child was starting kindergarten, and suddenly an arrangement that had been working for almost 4 years became almost impossible. Dad, who paid for the medical, dental, and vision insurance for the child and was fully employed, worked 50 miles away and had a 2-hour commute. And now that minor child was going to start school, dad didn't have the opportunity to just do transitions, which are called handoffs between mom and dad with the kid at his discretion. They had to happen at 8 in the morning and 2:30 in the afternoon when the child was going to start school and get off. Mom was unemployed, lived with her parents. I don't mean to denigrate her in any way. It's just the fact pattern. And she was living at home and just happy to have her kid there. And she expected the child to go to school in the local jurisdiction. Mom and dad did have joint legal and physical custody, even though they don't share equal time, which can confuse people. So I know it's rare, but when kindergarten starts, the commute's a big deal. And it's certainly a factor in whether a judge is going to decide to agree to any motions requested by either parent. So dad's opinion was realistically driving 2 hours to work and 2 hours home and having these set times with school, that it wasn't possible for him to be able to do that. So what happened was his work had offered to subsidize his housing here in the Bay Area. You pay anywhere from $3,000 to $5,000 to rent a house. It is that expensive. So his employer, because he was a great employee, had a good income, said, we're going to go ahead and give you $2,500 as a housing expense. We're going to include it in your W-2, so you don't even have to pay for it out of taxes or anything. We're going to go ahead and just pay that directly to your landlord. And dad took that opportunity. He requested to not only move to this different county where his job was, which is about 50 miles away, but a 2-hour commute during the school day and work day. He also requested sole legal custody because mom had been fairly abusive. In my opinion, not just an opinion, there was evidence of it. So mom opposed it. She said, I don't agree to that. I want the kid to go to school here in the county where he's lived for the last 4 years. And in defense of mom, there's no good guys and bad guys in family law. There's only what's in the child's best interest. You know, the uncles and grandmas and friends of dad as well were all local in this county, and all the connections were in this county, and the child didn't know anything or anybody in this other county. Because both parents were looking through the situation through completely different lenses, unfortunately, we have to have family law judges make the final decision. So to give you some background on the litigants in this case, just so you know their names and conditions have been changed, protect their privacy, is dad and mom had been co-parenting for 4 years, but mom had done some pretty abusive things. She had threatened to call ICE and have dad's babysitters and daycare providers deported because she had shown up late pretty continuously. And the daycare providers had reported that to dad. There had also been several allegations of abuse reported to mandated reporters and CPS directly. According to the information provided to CPS, those allegations were investigated and not only substantiated, but found to be a little vindictive and meant to harm dad and didn't carry a lot of truth, which is not a good idea when you're dealing with CPS. They deal with really serious stuff. Okay, which parent's better? Which is the good guy? Which is the bad guy? That's the wrong question when you're in family law. There is no bad guys. There's only what's in the best interest of the child, the minor child. That's always the judge's foremost interest when he makes a decision. Family court is not about handing out the parenting trophy of the year or handing out, prison time for parents who don't do their best. It's about doing what's best for the minor child. And I want you to know there is nothing fair about it. The parents were sent back to mediation before this initial subsequent court date. They couldn't reach an agreement. Dad wanted what he wanted. Mom wanted what he wanted. Dad also asked for full custody. And then mom counter offered or counter requested now a week for a week. So not only does she want joint legal and physical custody, now she wants equal parenting time. Dad saw this as kind of punitive, but that's her right to request that. So the child was already with him during the week. There's 23 school days or work days in your average month. So mom only had the child really about 3 to 4 work days or school days. And dad's argument was because he paid for all the child's care, which he pretty much did, not only his medical, dental, and other expenses in regards to insurance, but also the majority of his housing expense, food, clothes, what have you, because mom only had the child about 7 days a month. And there was one reality that the courts couldn't avoid. Somebody was going to be commuting either way. Dad was going to commute or the kid was going to commute. If dad won, mom would have a longer distance to deal with for parenting time as well, 1 day a week, or in the case if mom won her request, half 1 week for 1 week. If mom won, dad would have the commute, and because the child was with dad during the school week, the child would be making that commute as well. So the child would suffer 4 hours a day in a car. So there wasn't a magical solution where everyone stayed 5 minutes away from school and everyone got along great. These are the decisions that family law judges have to make every day. It's one of the reasons I have tremendous respect for that job. That was a very difficult job. The judge had to decide which arrangement created the least disruption for the child overall. And when I frame these stories for you, I'm trying to let you understand how the family law judge sees it so you can formulate and make your requests and your approach to family court to give you the best possible result, not only for yourself, but hopefully for your kid as well. The judge essentially, in the ruling, separated dad's needs from the child's needs. Dad was allowed to move to the other county, and he was also given sole legal custody of the child because mom was seen to be very punitive and vindictive, which is not in the best interest of the child. The court didn't tell dad where he had to live, but the judge did not allow dad's move to automatically determine where the child would attend school and change jurisdiction. The child was ordered to attend school in the local area where mom lived and dad used to live. And that meant something important. Dad was not going to have a significant commute, and so was the minor child. And because the child was with dad during much of the school week, the child was going to experience some of that commute too. And in addition, the judge did reject mom's request a week for a week. So mom still got 1 day during the week, every other week, and weekends. So the court wasn't choosing between child commutes and child doesn't commute. That's not what the judge did in this case. There was going to be traveling inconvenience under either arrangement, under any of the potential final judgments. The judge was weighing the inconvenience against something the court considered even more important. Continuity for the child, and the fact that numerous studies have proven, regardless of the difficulty of the co-parenting, children benefit from having both parents in their life. And in a way, it wasn't really ruling in mom's favor, but it was making sure and protecting that mom's presence in the child's life was not altered or made more difficult. Dad had a legitimate employment problem. Dad had a legitimate commute problem. Dad had a legitimate point that he was paying for the majority of the care for the child. And dad had a legitimate housing opportunity, which was a blessing in the Bay Area. But those were still primarily dad's circumstances. The court had a different job. The court had to decide what provided the most continuity and stability for the child while protecting both parents' presence in the child's life. In this case, the judge decided keeping the child's school and community local outweighed dad's request to move the child's school closer to his employment, even though that decision did create a hardship, not only for dad, but also for the minor child with a 4-hour commute, roughly 5 days a week. That's what makes being a family law judge so interesting and so difficult. And as a litigant or a paralegal or an attorney, when you approach a case, you want to look at it from how the judge is going to see it before you advise your client and give possible requests, motions, solutions, and amendments and alterations to custody orders to get the best possible result for the minor child, and hopefully not what's fair for the parents, but what's in their best interest. So the paralegal lesson is, the biggest lesson is when you're working in family law, you have to stop looking at custody cases, which your client wants you to do, as I'm the good guy and they're the bad guy, and we need to win and they need to lose. And you don't say that to them, by the way, just inner voice, keep that to yourself. I've had this job forever, and now I'm going to spend hours driving. Dad was very upset, for the record, but he was also happy he got full legal custody. These are all true. And mom also thought, and I can certainly relate to legally as well as emotionally, I don't want my child moved 2 hours away from the community the child already knows. I don't have a job. I don't have any money. I can't even get gas or a car to drive to this other county. And just so you know, having money to a certain extent is not a requirement to be a parent. The child was going to experience some inconvenience either way. That's the part some people miss. Judges aren't always choosing between a good option and a bad option. Sometimes I'll give you a great example. Life is three people drowning, and you have to save one. You can't save all three, and you can't swim. So, those are the decisions that judges have to make. There's no good option, and somebody's going to suffer no matter what they do. That's why they try to make the decision really primarily based on what's in the judge's best interest. The judge isn't there to be fair. The judge isn't there to pick who's the good guy or bad guy. The judge isn't there to give out the trophy of the year for the parent of the year. The child is the focus. What gives the child stability? What maintains important relationships? What gives the child the greatest opportunity to have both parents in their life, regardless of commute or what's fair? And then just a couple things the judge is required to think of when he makes a court order for a child is the child's schooling, the daily life, health, and welfare of the child, the community connections of the child, and also what's in the best interest of the child in regards to finances. And the inconvenience of both parents really isn't on the table. So, and sometimes it's even imperfect for the child. Like, for example, in this case, the child was going to suffer hardship as well. So the court's trying to decide which imperfect option is better for the child overall. And that's family law. There is no perfect answer. Thanks for watching the show. My name's Ben the Paralegal. I'll see you again with another enlightening and fun, exciting real case. I'm your host, Ben the Paralegal, and I'm genuinely grateful and blessed that you joined me today. If you want to go over to proparalegaluniversity.com, we have instruction lessons not only for paralegals and litigants, how to win your case, how to best present your case, and how to be effective with or without an attorney. If you enjoyed this episode, please like, share, and subscribe to the channel. It really helps us grow and lets me keep bringing you these real stories and lessons from life inside a law office and inside the courtroom. Until next time, I'm Ben the Paralegal, and I am grateful and blessed you spent some time with me today, and I'll see you in the next episode.